Welcome everyone to Jury Nullification 101. What is it and how do you use it? Presented by the Fully Informed Jury Association. With me today, I'm hoping we have all three panelists. Two have so far arrived, so I'd love to introduce them. We have with us today Clay Conrad, who is with Looney Smith and Conrad PC. He is also very well known in jury nullification circles as author of Jury Nullification, The Evolution of a Doctrine. So he is one of the few people in this world who can be said to have written the book on jury nullification. And he has also served as a past board member of the Fully Informed Jury Association. Welcome, Clay.
Hello, good morning. Thanks for having me.
We also have Catherine Bernard. Catherine is a FIJA Georgia State contact and a public defender with Bernard and Johnson, LLC. Did I get that right, Catherine?
You did.
Okay. She is also one of the few people I know, and Clay may correct me if I've missed anyone, but she is one of the few people I know who have actually won trials as a defense attorney by invoking jury nullification. So that is very exciting to me. Welcome, Catherine.
Thank you so much for having me, Kirsten, especially putting up with me having the sun in my eyes and possibly having to put the sunglasses back on.
That's okay. We see you on travel and we just appreciate that you're able to be here, as we are, Clay, that you are able to be here. We may have joining us a little bit later one more panelist, but we'll introduce him when he arrives. I'll just go ahead right now and get started. First, let me just say that if you have any questions, you can hover over probably the bottom of your screen, depending on what you're on, and ask that question in the Q&A. But we have a very specific agenda for today's program, so I may not get to all those questions. The goal today is very specifically to make sure that you are ready to show up for jury duty and you are as best prepared as you can be to get on the jury, stay on the jury, and deliver a just verdict, including using jury nullification if need be. There are a lot of philosophical questions, spiritual questions, moral questions, other sorts of questions regarding jury nullification, but those are not ones we're going to attack today. We're going to reserve this presentation for sort of the nuts and bolts type questions. I should mention we are not only live on Zoom, but we are also live streaming to Facebook. It looks like that worked. So again, if you have questions, go ahead and put them in the comments on Facebook or Q&A on Zoom. If we don't get to those questions today, I will do my best to address them at a later time. And with that, we've got our panelists introduced. I think and the question everyone always asks, will it be recorded? I have checked. It appears to be recording properly. We're going to knock on all the wood we have around us and hope that that goes well. But assuming that nothing goes wrong with that, we will indeed be posting that up on YouTube later. And if you are on Facebook, typically the recording is available a few minutes after the end of the webinar. All right, so with I think all of that out of the way, we will go ahead and get started with just a basic explanation of jury nullification for those of you who are not necessarily familiar with it. So in its strictest sense, jury nullification is when jurors refuse to convict someone, even though they believe it has been proven beyond reasonable doubt that the person did in fact commit the offense. A lot of people get this confused, so today I thought I'd attack it with some examples to help with the explanation. So let us imagine you're a juror on a trial where a person is accused of possessing illegal item X. It could be cannabis, it could be a gun, it could be a book of some sort that's illicit, whatever item, it doesn't matter. Let's say that they were in a community that has a car sharing service, and they were pulled over for speeding. A cop decided that there was a reason to search their vehicle, and in the trunk of the vehicle was found this illegal item. Now, suppose the cop says, "Is this your item?" And the person says, "Yes, that's my item, give it back." They have essentially admitted that they own it. So this comes out in court. You, the juror who have heard this, you could vote guilty because they indeed possess the illegal item. You also could be faced with a situation where they had this car from a car sharing service. This item was found in the trunk. They never admit to owning it or having any connection with it. In fact, they say, "That's not mine. I don't know whose that is." Well, that would be a great situation for you to vote not guilty because you have no way of knowing if it is in fact theirs. The fact that it's in a car that is shared by a lot of people, that it is in the trunk, which is not something everyone checks all the time. There are lots of reasons where you have reasonable doubt to think that maybe that isn't their item and they did not break the law. So those are the two cases when the court will typically tell you you should vote guilty or not guilty. But the court will not tell you about a third option. And if it does come up, they will typically lie to you about it or just not discuss it at all. And that is, suppose that person says, "Yes, that is my item." They've admitted it, but they still exercise their right to trial by jury. And you think, "Oh, well, that item isn't hurting anyone. It's maybe offending someone's preferences that this person has it, but it's not actually harming someone." I mean, I know they broke the law because they said it's theirs and that's illegal, but I don't really want to harm them. I don't think they've actually done anything wrong. So in that case, you can exercise your right of jury nullification and just vote not guilty. So that is a third option. If it is discussed in court, often judges will tell you, "No, that's not legal. You can't do that," or will strongly imply that it's not legal. There are a variety of ways they do that. But in fact, you have every right to do so. And if you find them not guilty, if you vote not guilty by yourself, that will not outright acquit them. But if the entire jury decides to vote not guilty, that will outright acquit them, and that cannot be overturned. And in the strictest sense, when you all vote not guilty, even though you believe beyond reasonable doubt that the law was broken, that is jury nullification. Now, the term has some other more colloquial uses. It is often called jury nullification when just one or a few jurors hang the jury by voting not guilty and refusing to change their vote. There's no requirement that you all agree on a verdict, so that does prevent the person from being convicted that day. They still can be retried later, but not being convicted is always a better position for them because number one, the prosecutor might not retry the case. Number two, if they do retry the case, at least they've seen the cards from the other side and know a bit better what to prepare for. And they might be offered a plea deal that's better than the prosecution was willing to offer before. So those are two common variations on jury nullification. Because there is a high profile case of this nature in progress, I will also mention that it is also sometimes called jury nullification in capital cases when a person is convicted of a capital crime, but during the sentencing phase, the jury knows that the conditions have been met that allow them to issue the death penalty, but they choose not to for conscientious reasons. So you'll sometimes also hear that referred to as jury nullification. I like to think of them all under one big umbrella of, I think the British use the term jury lenity, which is a way of just saying various ways of being lenient. So those are the sorts of things that you might be talking about when you talk about jury nullification. Now, there are a lot of debates over, should you do this? Is it legal? Blah, blah, blah. We're going to attack a certain subset of those questions today with our panel. I've already introduced Clay Conrad and Catherine Bernard. I see we have with us now our third panelist, which is perfect timing. Welcome to Tom Gallagher from Gallagher Criminal Defense. Tom writes about jury nullification on his website. He has tweeted about it. And I don't know, we'll have to check in with him. I don't know if he's actually won any cases by it, but it's certainly something that he has talked about as something relevant to the kinds of cases that he primarily focuses on, such as cannabis cases. Welcome, Tom.
Hi, had a little problem with my camera there for a minute.
That's okay.
Good to see you.
Good to see you too. All right, so the subset of questions we're going to be answering today are those things that are going to help you actually get on a jury and be able to nullify if that is what is just. So I'm going to start off with probably the most common point of debate and question, and we're going to throw this one to everyone for just a yes or no, and then we'll get into it a little bit deeper. Is jury nullification legal? Yes or no, Clay?
Yes. Yeah, there's no law telling a juror how they have to vote.
Catherine?
Yes.
Tom?
Yes, I think what judges say is that the jury has the power to nullify, which is kind of an interesting way of putting it, but yes.
Yeah. All right. Clay, would you just walk us through very, very basically, what is the legal foundation for jury nullification? What is it that makes this something people are able to do in court?
There are a lot of different aspects to that. The thing that gives jury nullification teeth is the double jeopardy clause. Once you've been found not guilty by a jury, they can't retry you, with one exception, which is that if you were tried and found not guilty in state court, the feds could still retry you in federal court and vice versa. So they both can have one bite at the apple.
Okay.
But once you've been found not guilty, it usually means it is over. As a matter of law, you are not guilty, regardless of what the evidence might have been. This goes way back historically, probably to before the Magna Carta. And it is also important, in my mind, to look at what the word jury meant at the time the Constitution and Bill of Rights were written. The law can change in a lot of ways. The law can change because the legislature changes it. The law can change because court cases might have reinterpreted it. In the case of the Sixth Amendment, the law has changed because the words that the founders used don't mean the same thing in 2022 that they meant in 1789. The founders understood the word jury in the case of a criminal trial to mean a jury with the power or the authority to judge both facts and law. And that, at the time, meant to judge the justice of the law, because back then, people followed what was called natural law doctrine, which was a belief that law existed in nature, and it was the job of lawyers and judges to figure out what the law was. The law resulted in justice being done.
Okay.
And this was natural law doctrine. It wasn't formalistic. It wasn't what we have now, which is sometimes called positive law doctrine, which basically means the legislature posited what the law is. The legislature stated the law, and we all have to do what they said. Back then, the law meant seeking justice.
Okay.
So if you look at what the founders took as the Sixth Amendment, you had a right to a jury trial. That meant a jury with the power to decide where justice lay.
So one of the things you've mentioned is that the situation has kind of changed over the years. And that kind of leads into a question that we get quite a bit, which is, hey, if this is legal, why don't attorneys just outright ask us jurors to do that? And I wanted to throw that question first to Tom and then to Catherine, because Catherine has a sort of a special situation, which we'll discuss. But Tom, why don't you just ask the jury to nullify?
Well, I think that's a possibility, but there is a lot of pressure, you could say, or intimidation factor from judges, generally speaking. I think it does vary from state to state, and perhaps from judge to judge, maybe from lawyer to lawyer. But there is definitely a general intimidation of lawyers against talking openly about jury nullification. And when you read judicial opinions discussing it, it's almost like they're disgusted by jury nullification, but they must admit it does exist, nevertheless. And so what lawyers tend to do a lot is talk about jury nullification without using the word nullification. So we can talk about jury lenity. So judges don't mind at all if we talk about jury lenity. That doesn't bother them. I think one of the dramatic conflicts, if you will, in a trial is the judge telling the jury that you must follow my instructions as to the law. And during jury selection, will you follow my instructions, or the judge's instructions? The lawyers might ask, especially the prosecutor might ask, will you follow the judge's instruction as to what is the law? Will you follow the law? So they're trying to instruct the jury to suspend disbelief about, the fairy tale that the law is just, and to just assume that it is, and basically abandon their duty as jurors to judge the law.
Yeah,
And
we're
so,
going to get into some detail on that when we talk about juror oaths.
But basically, lawyers, maybe a lawyer could be held in contempt of court by a judge if they openly talk about nullification. I think that lawyers need to push the envelope on that. I think everybody does. Judges do. We all have a role to play. You could be a juror, you could be a lawyer, you could be a judge. I think we all need to push in the direction of jury power. But I think it has varied over the years, but in the current environment, there's a hostility towards the word nullification being used.
Yeah. Now, Catherine, you are in the state of Georgia, and Georgia has an interesting feature in its constitution that is not as common in other state constitutions. And you have actually alluded to that in court. So you have been a little bit more able to directly discuss jury nullification than others might be. Can you talk a little bit about what that feature is and what happens when you bring it up in the course of a trial?
Certainly, and we are very lucky in Georgia. We have Article 1, Section 1, Paragraph 11 of the Georgia Constitution, which provides that in all criminal trials, the jury shall be the judges of the law and the facts. And there's a lot of ways legislators try to get around it. We have one Yale-educated lawyer in the legislature who tried to argue that the concept of law and facts was something different than what we might commonly understand to be two separate things, that it was actually a new legal concept that still the judge was in charge of telling the jury about, which is really patently ridiculous. A jury that does not have the power to judge the justice of a law is not really a jury. It's just a rubber stamp for the government. And we go all the way back to William Penn in the 17th century. We're about to celebrate Jury Rights Day, where preaching in the street was what he did, but it wasn't a crime according to the jurors. So we do have this constitutional provision in Georgia, which I have quoted to juries before. I did draw an objection from the prosecutor on that, but I turned around and I said, you know, ladies and gentlemen, this is exactly why we have a constitution, because judges and prosecutors will try to tell you something different, but this is why you write it down in a very important document that you all agree on. And so they can try to cite appellate cases or statutes or anything else, but we've got the Georgia Constitution right there. There's also some other avenues that are available here in Georgia as well as in other states, and those come in the jury instructions. The judge will almost always instruct the jury that if the evidence if they do not find beyond a reasonable doubt that the person committed the crime, then they must find the person not guilty. They have to find the person not guilty. However, if they do find that the state has met its burden of proving guilt beyond a reasonable doubt, they are authorized to convict. So the language that the judge uses in his or her own instructions right there can be very helpful in illuminating that issue for the jury. Also, most indictments contain some kind of language about the action in question being against the good order, peace, and dignity of the community. That's the language we use here in Georgia. And so that's another avenue I find that you can talk about concepts of fully informed juries with the jury about, because it's right there in the charging document. You can say, well, sure, you know, you've got these elements right here, but the judge is going to tell you the state has to prove every element. And they didn't prove that this person possessing marijuana was against the good order, peace, and dignity of the community.
Mhm.
In
Clay-
some states, if I may,
I
in
was just gonna-
a lot of states where marijuana is still illegal, prosecutors are giving, you know, like, okay, take this course and we'll dismiss sort of deals to people because they're terrified of having to take a marijuana possession case to trial. And I want to take one to trial. And I want
Yeah.
to voir dire the jury and tell them,
Yeah.
look, you know, you can decide any witness is lying. You don't have to believe any single witness, no matter what they say. Even if the defendant takes the witness stand, you don't have to believe him.
Mhm.
And then have the defendant take the witness stand and confess to everything.
Yeah. One question I
But in
did have
Texas,
for
juries do sentencing, so then I could ask for a one-penny fine if they
Yeah.
do convict.
One question I did want to ask you, because it seems very common, Clay, you had mentioned while we were getting set up for the webinar, that there have been motions in limine filed before trials, basically to preclude discussion of jury nullification. Can you just briefly explain what a motion in limine is in general, and then like what sorts of things it would preclude people from talking, or attorneys from talking about?
A motion in limine is a pretrial motion that you take to the judge and you say, okay, we don't want anybody raising these issues during the trial because they're not relevant to the trial. It could be the defendant's prior offenses. You don't want those being discussed in front of the jury because, you know, you don't want to convict people based on their past. You want to convict them on what they did in this case. And it's not fair to, you know, say that because they did this before, they did it this time, so convict them. In the case I was talking about, I had a prosecutor file a motion to try to prevent me from discussing jury nullification because they noted that I'd written a book on it, yada, yada, yada. The problem with that motion, though, is that if the prosecutor had actually read the book, he would know that I talk in there about how you don't go at this head on. Usually you go at it through metaphor and guidance, not through direct exhortation.
Mhm. Right.
There was a study done, back in the early 90s or late 80s that I read that I thought was very interesting, and it showed that most of the time when juries nullify, they don't know that they did it. They think they followed their directions, but they interpret their directions so as to lead to a just result.
Mhm.
In other words, let's say that you had an illegal gun possession case. And you make a big thing out of the fact that the gun was only for self-defense. It was never pointed at anybody. It was just in the nightstand. And you deal with those issues as though they were elements of the case that the government has to prove.
Mhm.
Then when the jury goes into the jury room, they're going to be talking about how it was only for self-defense, blah, blah, blah. And they will, in their mind, view those things as elements because in justice, they think that those things should be applied.
Mhm.
So they come back with a not guilty. They think they followed their instructions. But in fact, they were
Yeah.
changing the elements of the case in their mind so as to come to a just result.
So I think kind of the bottom line for jurors on this is that, yes, it is legal that you can do it. There is legal basis for it. But here are some reasons why you're not going to be asked outright directly in court to do that. So it's kind of on the jurors themselves to kind of take the initiative in that regard. Is that fair to say?
Yeah, the guy in the black dress carrying a hammer is going to shut you up if you try to discuss it directly.
Yeah. All right. So the second big hurdle that people have, there's kind of a small hurdle, which I'm going to scoot to the end, even though I have as my second topic, because I think it's a little bit easier to discuss. But one of the biggest things that has just absolutely impeded people from doing justice is juror oaths. Here they go into court thinking, all right, I know about jury nullification. I'm going to do it. And they're honest people. So they want to speak honestly and say honest things and uphold their agreements that they make. But then they are smacked in the face when they get an oath told that they have to swear or affirm a certain oath. And there seem to be, I've studied over the last year or so a number of oaths from real trials because the oaths seem to be evolving to become more intimidating and more bullying of jurors to keep them from exercising their right. So Minnesota presented an interesting opportunity because of a particular high profile trial that was live streamed during the pandemic. And so, Tom, you're from Minnesota, so maybe you can attack this first. It seems that the law says that the oaths should be substantially similar to the following. Quote, you each do swear or affirm that without respect of persons or favor of any person, you will well and truly try and true deliverance make between the state of Minnesota and the defendant according to the law and the evidence given you in court. First of all, what are you agreeing to if you affirm that? And does that preclude you from legally exercising your right of jury nullification?
Well, I think that language, it puts an emphasis on, again, following the judge's instructions as to the law, and requests in jury instructions. It kind of refers to or echoes jury instructions that tell jurors to follow the law as instructed by the judge. And that is really contrary to the juror's rights and the power of jury lenity or jury nullification, if you will. And I think it's a contradiction, and that it creates a lot of problems, I think. And I think that a lot of states, maybe like New Hampshire, they are going the other way.
Nope.
They're not? Okay.
Let me squash that right there.
All right. Well, hopefully
Sorry,
other states,
they tried.
maybe Georgia. I'm less aware of other states, but
Yeah.
I've heard that there are other states better than Minnesota when it comes to jury rights, but Minnesota has a lot of work to do.
Well, this generic oath to me didn't seem nearly as bullying as the actual oath that was administered during a police officer who shall remain nameless because he's not the subject of our discussion, but his actual trial. This, I took notes from the YouTube recording, and this is what the judge said, quote, "Good morning, everyone. Members of the jury, before we begin the trial, will administer an oath to you so that you may take on the important duty of being judges. In this case, you will be the judges of the facts, and I will be the judge of the law. I'd ask everyone in the courtroom to stand while the oath is being administered. Raise your right hand, please. Do you swear or affirm that you will be attentive during this trial and follow the instructions of the court so that you may reach a fair and just verdict, that you will not discuss this case with anyone until submitted to you for deliberation, and will keep your verdict secret until it is delivered to the court? If so, say I do." So here he's saying that I'm the judge of the law, I, the judge, am the judge of the law, and is coercing them to say that, yes, I will follow the instructions of the court. So they're essentially signing up, it seems, under this oath, if they swear or affirm it, to do what they're told. Does that, even if they do that, does that legally preclude them from exercising jury nullification? Could they be, most people want to know, could they get in trouble for it? Could they be prosecuted for perjury, etc.? What does that do in terms of putting them in a legal position?
Well, in Minnesota, the answer would clearly be no, you could not be prosecuted for delivering a jury nullifying verdict. It is, the Minnesota courts have said, is the jury's power. It's the fundamental nature of a jury trial means that they have the power to judge the facts and the law, and they have the power. So they create kind of a strange verbiage, wording of it, where they say that, well, the jury must follow the law, but they have the power to veto the law, basically, or to overrule the law. So they're trying to have it both ways, in a way. They're trying to say, well, the jury must follow the law as the judge instructs the jury, but the jury can ignore the judge's instructions. They have the power to do that, and nobody can stop them. And on appeal, they won't try. Then they cannot arrest you. They cannot charge you with a crime. They can't do anything to a juror or a jury that delivers a not guilty verdict.
And then we'll have Catherine first and then Clay second also weigh in, because you're from different areas, and it would be great to get sort of a cross section of the community on that. Catherine, what do those oaths kind of impose on people, and can they still exercise jury nullification under those?
They certainly can. There is nothing that the judge could say whatsoever that would in any way take away the jury's power to decide the case according to their own opinions. That's the entire point of having a jury made up of people from the community, rather than people who are being paid by the government to serve in a particular capacity, like a judge. So I certainly don't think that there is any legal weight to it, but I think that the moral and cultural weight that you're discussing, I know you said we weren't going to get spiritual and philosophical, but I think the way that people feel when they come into a courthouse with members of their community, do they feel scared and intimidated? Is it something where they feel like they don't have any control over the process? Or is it closer to, what the founders intended, which is, hey, we're coming up to our public house where you guys are doing our business. Now we're here to check up on the judges to make sure that you're doing it correctly. That's the way juries are supposed to work. And so I frequently tell them during closing arguments, you notice that everybody stands up whenever you enter or leave the room. It's because y'all are the most important people in this courthouse. Your decisions are the ones that carry any weight. Nobody else's matter.
And Clay, did you want to give some thoughts as well on that? Whether those oaths preclude someone from legally exercising jury nullification, and are they at any risk for being prosecuted for doing so?
I have heard of people being prosecuted for lying in jury selection. I've never heard of someone being prosecuted for violating their oath.
Wonderful.
And in those cases where people were prosecuted for lying in jury selection, it's only very rare instances like, oh, I know the defendant really well, but I didn't mention it, that they would actually be convicted. It's only in cases where they got caught in a relevant and material lie. Usually, for instance, there was the Laura Creho case where she was prosecuted for lying in jury selection, but
There are air quotes there for anyone
she
who's
didn't
not got
lie.
their
She
eyes on
just
their
didn't
screen.
volunteer information.
Yeah.
And the court
That
said,
wasn't asked for, correct?
yeah, you don't have to, just because you know the prosecutor wants to hear it. If they didn't ask you that question, you don't have to go and volunteer something.
And we're going to get into that a lot in the next section, because we're going to talk about what do you do about jury questionnaires and answering questions live in court. But the last thing I do want to kind of go through on the oath is, I get a lot of people who say, well, I can't agree to that oath. I'm going to question it. I'm not going to take it. I'm going to refuse to take it. We had one person contact us because she felt like the oath was not allowing her to do jury nullification if she felt that was right. So she refrained from taking it, and then quietly went aside to the clerk of the court or bailiff or somebody and said, yeah, I didn't take the oath because I have these concerns. Is there a way I could speak with the judge? And the judge singled her out for public scoldings in his courtroom, required her against the law, I believe, to stay for the entire trial and sit in what she said he treated her like a naughty little child and told her she had to come to court every single day and sit through the whole trial, and then gave her another tongue lashing publicly at the end of it. So all because she didn't want to take this oath that she felt was bullying her. But for me, for most jurors, I mean, that's disappointing to me on many levels, of course, but I feel like she selected herself out as she could have been that person's one fully informed juror who knew about jury nullification, and she opted out by saying, I'm not going to take the oath. So while I can understand why people would do that, like, is there any value in taking it? Like, Tom, you had mentioned you would like to see people in all these various groups push back. Is that an effective way of pushing back, or is that something that it's just better to take the oath and serve as a fully informed juror? What are your thoughts?
I have not given that a lot of thought, but I'm pretty sure my answer would be I would not challenge that. I probably would just accept it and then move on and do what I'm going to do.
Okay. Catherine, take the oath or make a stink, I guess.
Err on the side of taking the oath, because there's nothing in that oath that prevents you from doing justice under the law. You know, the way they phrase it in Georgia is that the judge will say, you must decide the case based on the law that I give to you. And it's interesting to hear the way judges, sort of focus on, put the emphasis on different words there. They really like the idea of sort of handing down the law, like they're a bunch of, medieval monks who, they speak Latin, and so they can explain the law of what God wants to the rest of us peasants. But, we certainly couldn't read it for ourselves. But I do think, like, this is, again, where the cultural stuff comes into play. If you go into the jury selection process, dressed nicely, making connections with the people around you, and the prosecutor or the judge starts, asking very aggressive questions, sometimes that's an opportunity where you can make a public statement in front of the rest of the jury pool. And even if it means that you might personally not get selected, you have raised some important questions and issues in the minds of the other jurors. Mm-hmm. But the point that you made about the judge treating someone like a naughty child, that absolutely happens. So you really have to be prepared. You have to know your own courthouse. You have to know the community, the size of the community, whether you have connections to other people there, and really read all of those different factors before you can decide, is this the place to stand and fight? But like I said, I would err on the side of going ahead and taking the oath, because of course, you're going to do justice. You're going to follow the law and do the correct thing.
Okay. Well, let's get into our next topic, which has to do with answering jury questionnaires you might be sent ahead of time and answering in-court questions during jury selection. And Clay Conrad has actually written an essay that I've seen published in various places under different titles, but it's pretty much the same essay. We have it on the FIJA website as Surviving Voir Dire, and it is an excellent thing to review before you go to jury duty, because it kind of gives you ways to look at different questions you might be asked, so that you can answer them truthfully but neutrally, is kind of the way I look at it. Clay, you've talked about the fact that people can, and it rarely happens, but it has happened, be prosecuted for lying during voir dire. But what alternative is there to that for someone who wants to be honest, but also still doesn't want to get themselves kicked off a jury? Maybe if they're asked about in one of the indirect ways that sort of people poke at jury nullification is asking, what are your thoughts on this law that is involved in this trial, and would you be able to uphold it, and that sort of thing?
Well, I think the real focus of that has to be on the word able. I am able to walk in front of a speeding train. I have no intention of doing so, but I am able to do that. So would you be able to enforce it? Of course I'd be able to. I have the physical capacity. So you're not lying if you said you'd be able to. If they ask you what you think about the law, you can say, well, I have questions about it. I haven't studied it in detail.
So
Great.
is less is more kind of a good policy there? Like, don't spill your guts necessarily?
Absolutely. Yes or no, if the question allows for it. You don't have to volunteer anything.
Mm-hmm.
And you don't need to give a speech unless you're going to get kicked off the panel anyway. In which case, let's say that it's already come out that, you're the normal director for your county or something. You're not going to get on the jury. So in that case, you can give a little speech, basically on your way out the door, to try to get other people along
And
with you.
When you
You
say
can
little,
there is just no way in the world that I would send someone that I could consider sending someone to jail for something as innocent as what this guy's accused of.
And when you say little, I think we should specify, we're not talking 5 minutes. There's no way you're getting 5 minutes the judge will shut you up pretty quickly. I've actually seen that in court. So it's got to be like, have that prepped and ready to go.
Yeah. 2 sentences.
Yeah.
And if the judge interrupts, just keep talking till you're done. What are they going to do?
Yeah.
The judge is being rude.
Tom, what are some of the questions that you have seen asked in court that sort of poke at whether or not someone is going to be willing to follow the judge's instructions and do as they're told as a good little juror getting patted on the head?
Well, I had a jury trial in a marijuana DUI case last summer, and the prosecutor in that case, I was kind of surprised because I'd used the analogy myself. I think it was kind of a classic law school and kind of analogy or whatever, but or metaphor. And the prosecutor asked the potential jurors on the panel during jury selection, now, if the law said that it was illegal to wear a blue shirt on a Tuesday, would you be willing to convict if the evidence did prove that the defendant was wearing a blue shirt on a Tuesday? He asked that of the jurors. And I was kind of trying to keep my poker face on because I wanted to laugh, but I was kind of looking at the potential jurors, and they kind of looked puzzled by that a little bit. And I think the one that he was talking to pushed back on that and said, well, I'm not sure if I would do that.
What
But
would
I
be,
thought that was a direct affront. I thought
Yeah.
that was an attack on potential jury nullification, or he
Yeah.
was probing for fear of that.
yeah. And what would be a truthful but neutral way for someone who is willing to consider jury nullification to answer that? I have come up with some thoughts myself, but I would like to hear from the.
I feel like there's sort of two possible approaches that are contradictory, and I can't necessarily pronounce one better than the other
Okay.
because they've both worked in the past, I think. But one approach is to kind of go undetected and get on the jury so that you can do justice without being bullied by the government, by authoritarians in the system. And the other approach is sort of the opposite of that, where the juror says, you know what? No, I would not convict somebody of wearing a blue shirt ever. You know, that's just not something I would ever do because it's ridiculous to make wearing the color of your shirt a crime.
Mhm.
Or
And is that
I remember
that second approach is that going to get them kicked off?
I read a report of a jury trial in Wyoming, I think it was maybe 5 years ago or something, where during jury selection, everybody in the jury's panel said they wouldn't convict on marijuana, and the judge just pronounced a mistrial or something. And I don't know.
That was us, Montana.
Oh, was it Montana? Okay, I'm
Yeah.
sorry. One state
That
off.
was
Okay.
Missoula. I'm very proud of us.
So I think that's kind of an example of the opposite approach, where you're not hiding it. You're just like,
Yeah.
marijuana should not be a crime.
Yeah. I will say in that particular case, the city of Missoula had passed an ordinance saying that cannabis enforcement was to be the police's lowest priority. And then they come and charge someone with possession only of 1/16 of an ounce of cannabis. And everyone was like, didn't we just pass this thing that said you're not supposed to be doing this? So that culturally was probably a conducive environment for that. But for the most part, if you say that you wouldn't convict Mr. Blue Shirt, you're not going to get on the jury. Is that
right? I think
Okay.
the prosecutor is going to bounce you out of there very politely.
It would be interesting to then ask the jury, and what if it was a capital offense? Then would you be
Yeah.
willing to convict?
Yeah. Let me run by Catherine a couple of things that I thought of for that and see how you, Catherine, think these would fly or not fly, and if you have any other thoughts on how to answer this. I've thought, number one, I could just say the law is the law. That just states a truism. It may imply an attitude that I have, but it doesn't outright commit me to agreeing to that. I might ask a question and say, isn't that what we're supposed to do? Like, I'm confused. I'm not making a statement. I'm just asking a question. Or kind of playing off of what Clay was talking about before, I could say, I could do that because I can, but I'm not committing to it. Do any of those, do you sense any pushback that I might get from the person asking the question, or have any thoughts on how those might play in an actual trial, and what are my odds of sliding through on those?
I think those are all excellent answers, and I think they would all be pretty decent at flying under the radar somewhat. I am interested, though, when Tom first mentioned that question, I thought a defense attorney might be asking it, because it was really phrased so wonderfully to point out that laws can be ridiculous. So I would find myself tempted to, suggest that a juror turn the question right back on the prosecutor and say, wait, are you saying you would convict someone? Is that what we're supposed to do here?
I like
So
that.
you got to read the vibe of the courtroom.
Okay.
But to me, that's
Yeah.
a fantastic question for the defense.
Right.
The one that I have dealt with and worried about in the past, and the one where I think lawyers can really step up, is where lawyers ask, does anybody here have a problem with convicting someone for marijuana? And I object to that because they're asking the juror to judge the issue, to prejudge the issue of the case that they are being selected on a jury for. And so often you can kind of get out some information about the Constitution, jury nullification in general during that speaking objection. And so that has been an effective one for me. And usually it's about empowering the jurors, but that's one where the lawyers definitely can battle it out with the prosecutors about, hey, it's totally inappropriate for you to be making these inquiries of the people that we are trying to decide if they're going to serve on an impartial jury for us.
Mm-hmm. Yeah. Another type of question that seems to trip people up, and I'm going to throw this one over to Clay first, is people will be asked if a police officer is giving testimony, are you more or less likely to believe them as opposed to any other witness? And a lot of people who've had bad experiences with police, that is like hitting a button for them to just completely unload their soul, which I can totally understand.
Oh, we had jury selection a couple weeks ago in a case, and there was this one young man on the jury who was just, no, I'd give them less. And of course, he got struck by the state. And I was sitting there going, shut up, shut up.
What would be an alternate way that someone might answer that a little more neutrally without lying, but still kind of go under the radar a little bit better than F the popo or something?
Just say no, because the truth is that young man would not have given the police officer more credibility.
Mm-hmm.
So the truthful answer for him would just be to say no.
Yeah, it's kind of interesting.
Answer is always best.
Yeah. It's kind of interesting, the psychology of a question like that, because when it's worded, would you give more or less weight to their testimony? It's almost like leading someone to say that the answer has to be either more or less. But as you point out, the answer can be no, meaning, it would just be the same as anyone else. And that kind of makes a little bit more, going outside of where you're being led is a way to answer that without maybe tipping your hand.
Absolutely. And, there's an old saying among criminal defense lawyers that even a fish wouldn't get caught if it kept its mouth shut.
Mm-hmm. Yeah.
And the same thing is true of jury duty. If the people who get on the panel are always the ones who say the least, because the more they talk, the more they're going to piss off one side or the other. Mm-hmm. So the more down the middle, neutral, I don't have a dog in this hunt, you can appear, the more likely you're going to be one of the ones that gets on the jury. But if you feel the need to run your mouth, then one side or the other is probably going to kick you off.
Yeah.
A lot of times what I see is people trying to get off the jury. That it's what I've always told people they need to do if they want to get off the jury is just either wear a FIJA t-shirt or carry my book with them.
Please don't wear a FIJA t-shirt. Please leave Clay's wonderful book at home. But one of the related sorts of questions that also I've heard asked in trials about police is, asking people to describe their experiences with police. And depending on what neighborhood you're in, depending on a variety of social and cultural factors, you may have had a lot of experiences with police and they might not have been good. How much detail do you need to get into if you're asked sort of an open question, such as how would you describe your experiences with police?
Some good, some bad, just like anyone else.
Catherine, did you want to weigh in also?
Well, I was just thinking that I practice in a lot of smaller communities where a lot of people know each other. And so that question about law enforcement credibility, it's one that I often ask, particularly if someone has a close relationship with folks in law enforcement. And it has often prompted very interesting discussions. You know, people will say, my ex-husband was a police officer, so I give them less credibility. And so again, you have to weigh that, you know, if you have a particular instance that might be compelling to a larger audience, you know, you do have to weigh, maybe I'm not going to get on this jury, but if I can credibly and thoughtfully inform everyone else in the room and kind of change that tone a little bit, then it might be worth it.
Mm-hmm. And Tom, any thoughts on how much detail you have to get into when describing your experiences with police?
Well, I think I would echo what Mr. Conrad has said. You know, the less you say, the more your chance of getting on the jury. But I mean, I think people do want to be honest and responsive usually. And so I don't know. I mean, I personally have had good and bad experiences with police. I think it's not that hard for a lot of people to say that, but I think sometimes there are racial issues and cultural issues that come into play. So certain maybe racial class members might have more negative experiences with police. And I would kind of expect that in Minneapolis where I am.
Yeah.
So I think it varies a lot, but.
Yeah, that's kind of a tough thing because it seems like if people who've had bad experiences with police are all getting kicked off juries, that would skew how the jury decides to be more favorable to the government in a lot of cases. So I don't want anyone to get in trouble or feel bad about their jury service, but at the same time, I'm trying to find ways that they can actually avoid getting removed by, you know, by answering a little more neutrally than.
I think the old song lyric, it ain't what you say, it's the way that you say it.
Okay.
There's a lot of truth in that as well.
Yeah.
Well, and it comes down to the magic words, you know, I will judge all of the evidence. I've not made up my mind. I don't have a bias one way or the other. I will listen to all of the evidence and decide at the end of the case.
Yeah. I'm glad you said that, Catherine. I have a question I want to run by all of you because I think it's one of the biggest sources of people inadvertently selecting themselves off of juries. Essentially, to be on a jury, you at some point have to project or possibly outright state that you will be fair and impartial. But in reality, none of us is a blank slate. We all come with certain life experiences and certain opinions and whatnot. But it seems like people who have a lot of strong opinions about the law are like, well, I can't be impartial because I have an opinion. Well, everyone has an opinion, but not everyone's selecting themselves out. So starting with Clay, what does it mean to be impartial in this context? And does having an opinion about the law or about how it's enforced or things like that, does that mean you can't be impartial?
Well, what they will ask you in court is, can you set that opinion aside and judge this case solely on the facts? And in judging the case, part of judging the case is to decide where justice lies. And yes, you're going to decide where justice lies based on the facts. What else do you have to go on? So I would think that the answer to that would certainly be yes. They will ask about your relations with police. They will also ask whether anyone on the panel has ever been a crime victim, whether they've served on a jury before, all those things to try to figure out who's going to be favorable to one side or the other. And, they call it jury selection. It's really jury deselection.
Mm-hmm.
The ones with strong opinions on either side get lopped off, and the ones in the middle remain.
Mm-hmm.
So your goal is to appear to be straight down the middle, if you want to serve on the jury. And the world is run by those who show up.
Mm-hmm. Yeah.
And so if you don't get on the jury, you have no impact on how the case comes out. So if you want to see justice done, then you want to get on the jury. And if you want to get on the jury, you need to keep your mouth closed as much as possible. You can't lie. You can't lie. But you don't have to volunteer anything. And you don't have to take any strong positions.
Tom, as far as being fair and impartial, what are your thoughts on whether someone who has opinions about the law and how it's enforced, can they honestly say they can be fair and impartial, and should they deselect themselves, or how should they deal with that?
I think the context within which that question most frequently arises is what lawyers call a challenge for cause. At least in Minnesota, we call it that. So there's two types of challenges to potential jurors. One is called the peremptory challenge, where each side gets a certain number of them, where they can just exclude anybody they like, limited to some small degree by a Supreme Court case talking about racial, religious, other biases. But then the other type is called a challenge for cause. And so a lawyer would always like to get rid of a potential juror that they don't like for cause, because then they preserve the number of peremptory challenges they have. And so if a lawyer thinks they have a chance of success at that, we will ask some questions, sometimes somewhat leading questions of the potential juror, to try to disqualify them in the eyes of the judge as incapable of being fair, essentially. So judges will typically try to rehabilitate. Some judges are more active than others, or the prosecutor may ask questions of the potential juror to try to rehabilitate that juror. And so the juror could say all kinds of very biased things, but then the judge says, well, but could you be fair? Oh yeah, I could be fair. And then, okay, well, then I'm going to deny the challenge for cause.
And then if they want to get rid of you, at least they have to use up one of their limited peremptory strikes.
Exactly. So it's kind of another level of the game theory here. But if they're going to get rid of you, don't let them get rid of you with a challenge for cause is kind of one idea.
Great.
So you want to say, no, I could be fair.
Mm-hmm.
Yes, I've had a lot of bad experiences with law enforcement. Yes, I think marijuana should be legalized, but I could be fair. Then that would make it that would make it less likely the judge would remove you for cause.
Mm-hmm. Yeah.
And then the prosecutor would have to use up one of their peremptory challenges to get rid of you. At least that would be something.
Yeah. Well, I have 3 topics left that I definitely want to get through. So, and I also want to leave time for each of you at the end to mention anything that you thought was important that we didn't cover. So I'm going to consolidate 2 of these topics and go to Catherine on these. You had talked a little bit about jury instructions, and often, so the standard has up until very recently been that should acquit, may convict language that you talked about. But more and more we're seeing in jury instructions, again, as with the oath, more language that says that they have to follow the instructions as the law, follow the law as the judge gives it to them. And then during deliberation, someone who wants to nullify, I love you, jurors, you're all heroes to me, but you're not all juror number 8 and 12 angry men. I know when I was being called for jury duty, I had, these fantasies about how I would be the lone person who knew about jury nullification. I would explain it to everyone else. They would see the light based on the eloquence of my defense of the concept and all that. And then they would all vote to nullify with me. So given these jury instructions that are becoming more common, and should you discuss it, Catherine, with your fellow jurors, or how should you deal with deliberations? Openly bring up jury nullification, keep quiet about it. How do you do that? What's the...
I think my advice would be start with the facts of the case. Don't start with some abstract legal doctrine that might not really have any connection for people. You talk about what you're there for, which is the government is trying to put somebody in prison, and y'all have been summoned there to decide if that's the appropriate thing to do. So I think you do want to kind of drill down on the facts that have been presented in court and any particularly sympathetic aspects that might sort of play into a jury nullification argument. And I think my colleagues brought that issue up earlier, that a lot of juries don't think of themselves as engaged in nullification. They just think of themselves as doing the right thing in a particular circumstance, which is exactly why we have juries. So I think the more you focus on just the human connection of, hey, we have the power here, we have the opportunity to do the right thing, let's figure out what the right thing is. And it's that guy in the black dress, he doesn't have the final word on it.
Mm-hmm. And Clay, what if I decide that no matter what happens, I'm nullifying? Should I just say, well, I'm voting not guilty and I don't need to discuss it? Should you just, kind of go off in a corner and do your own thing? Or what do you have to do in this deliberation situation, like to at least have your vote count in some way?
The strategic thing to do, the best answer to that is to say, I don't think he's guilty, but even if I did, I would vote not guilty because this case is stupid and the prosecutor should never have brought it.
Mm-hmm. Now, let's say your fellow jurors are like, hey, that's not what the judge said, and one of them squeals on you to the judge. Is it that you're on the jury and that's all there is? They're stuck with you, or can you be replaced? What are the risks
and this
there?
is a case called U.S. v. Thomas that came out, I think, in '97 from the Second Circuit Court of Appeals. And what they said is that if there's any possibility the juror is voting on the facts, you can't kick them off the panel.
Okay.
If you know they are nullifying, if they come in and say, stupid law, no way I'd convict under this, how dare that prosecutor waste all our time this way? Mm-hmm. Then they can kick you off the panel. But if you say, I don't believe this cop, mm-hmm. I thought he was lying, he looked squirrely as hell to me, it's a stupid case that never should have been brought, and they're bringing liars to try to make it. Mm-hmm. He's not guilty.
Okay.
If
as
you
long
have
as you
a factual reason to vote not guilty, okay, and you tell the judge that, he can't kick you off. Okay. If you admit to nullifying, he can kick you off. That's why I say the best thing is to say, I have a reasonable doubt.
Okay.
But
then attach the extra.
Yeah.
Okay. Tom, what are your thoughts on that approach of expressing reasonable doubt and then sort of like floating it as a side thing, sort of the, hey, it's a dumb law or whatever?
Yeah, I think I agree with others that justice is really the touchstone here. It's really about delivering justice, and jury nullification is a vehicle for delivering justice, but you don't have to call it jury nullification, and they don't want you to. So maybe it's better not to call it something else. Call it jury lenity. They like that word better. But it's really about justice and the facts. And if the law is wrong, you can still acquit. I mean, sometimes I think a related concept is sometimes we see compromise verdicts that are not justified by the facts. So it's not a complete acquittal, but some kind of a lesser included offense. Like when I had a marijuana case where it was over 50 kilos, but the police harvested the marijuana and there were tree branches and rocks in there. So I was arguing it's not guilty because this isn't marijuana. This is tree branches and rocks. And and there might be some marijuana mixed in. Well, they came back with a conviction, unfortunately, for less than 50 kilograms, which was arguably not justified by the facts. Maybe arguably it was, but I think I think the jurors, if I was on the jury, I would try to be persuasive about justice and what is fair and what is right.
Okay. Now, sometimes you're just not going to get everyone on the jury to agree, and the jury is said to be deadlocked. Some people are voting guilty, some people are voting not guilty. I have one of the most heartbreaking types of contacts I get from people is saying, well, I couldn't ever get everyone else to agree with me, so I changed my vote so I wouldn't be stuck there forever. What actually happens if the jury can't agree? And should you change your vote to guilty if you can't get everyone else to agree not guilty? Catherine, we'll start with you.
Thank you so much, Kirsten. I appreciate it because, like I said, I apologize. I thought this was 1 hour and I have to be on with the federal judge.
Sorry, we'll cut you loose as soon as you need to go.
Yeah, I'm so sorry, but there's a lot of different things that, again, it depends on the judge and the courtroom and the community. They often like to send the jury out at 5 o'clock on a Friday or some other time when there will be a lot of pressure on people to agree. I once had a jury stay out until 9 p.m. on Friday. And then over the weekend, the state arrested one of our witnesses and put her picture in the newspaper. So that affected deliberations on Monday, unfortunately. So there's really a lot of different things the state can do. They can fill the courtroom with officers that can be very intimidating to people. They can, just bring in other people from the courthouse. They can suggest, we're not going to let you go until you come to a decision. They can read what's called the Allen charge or the dynamite charge, saying you really, really have to try hard. But people just need to be aware that you have the full power to vote your conscience no matter what. And even most jury instructions will note that specifically, that you should never surrender an honestly held opinion just to be congenial. And so I think you can remain polite. That's what really causes problems, is when people get kind of upset or irritated, then the judge can say, oh, well, this person is having problems. We'd better replace them. So you just have to stay calm, cool, and collected and say, I respect everything that y'all have said, but I listened to the evidence and my vote is not guilty.
Well, thank you, Catherine. I want to give you if you have to go, totally understand, but I want to give you your shot at 1 minute of anything you think we haven't covered that you think might be a hole that needs to be filled here.
Well, I love Fully Informed Jury Association and the idea that we need to reinforce the jury is where you can protect and serve your neighbors. Voting is so much less powerful and so much more attenuated. We need to encourage people to serve on juries. We need to encourage them to be informed about their role. And so I just really appreciate what y'all are doing, because the more it becomes an issue for lawyers and judges to argue about, the more intimidating it's going to be to the people who are serving on juries necessarily. And, whether that's the architecture of the courthouse or the uniformed officers showing up, there's just so many ways for the state to intimidate people. So we really need to reinforce that the jury is the highest authority for a reason. That's why we trust 12 people who don't sit in the justice system all day to come and give us a fresh perspective on a complicated factual situation that affects individuals.
Thank you so much, Catherine. We really appreciate you being here, and feel free to stay for as long as you can, but pop out at any time that you have to go do the work of justice. Catherine did
No
mention the
problem. I just got to go plead a gentleman not guilty on a drug case.
All right, go get them. Tom, Catherine mentioned the Allen charge. Can you, and it's sometimes called the dynamite charge, can you explain a little bit about what that is, when it is issued, and what that means for jurors?
Well, so if a jury, what usually happens when before that comes up is a jury sends a note to the judge saying, "Judge, we are hopelessly deadlocked," or something to that effect. How long do we have to keep going? Because we're not getting anywhere, we're stuck. And then the judge will sometimes come back with an Allen charge or a dynamite charge, trying to provoke the jury into a unanimous verdict one way or the other. And it's intended to be coercive with that, with the goal of a verdict, which has to be unanimous. So I think what's important to know or understand to be a fully informed juror is that you absolutely can and should and must stick to your conscience and stick to your guns and do what you think is right, because that's what it's all about. The jury is the cornerstone of democracy, and it's the one chance for people who are not elites, who are not lawyers, legislators, judges, elected officials. It's really the most direct involvement that the people have in the judicial system, and it's so important to stick to your guns. And yes, there could be a hung jury. A lot of times an Allen charge or a dynamite instruction comes just before the last, it's kind of the last gasp, where the judge will throw in the towel and say, okay, mistrial, and then it's over.
I think in my experience, I've only heard of the Allen charge ever be given twice, no more than that. So, and I don't think there's a statutory limit on that. They could theoretically do something different, but in practice, it seems like if you just hold out long enough, you're going to be okay.
Right.
I know it can get intense in there because people like have the lives and want to go home and can get a little testy and whatnot. But I always try to remember there's someone's life at stake there. I want to, the topic I skipped, it looks like we're going to have a little time to get to, and I'll still have time to give you all your final word. Clay, I wanted to run this by you because when you're getting ready to go to court, you're doing things like picking your outfit. You're picking what stuff you're going to take with you, maybe like reading material. You are selecting jewelry. You're selecting your hairstyle. You are maybe thinking about what's on your social media. What are the things you can do to prepare for court? Should you dress a certain way? Should you bring or not bring certain things? Should you hide your social media, delete stuff, or make it private? What are some tips for getting ready to go in there and get on a jury?
Well, prosecutors and defense lawyers very rarely have time to check social media. If we could, we would, but we just don't have the ability to do so. You've got a panel of 65, 80 people there and very little time to check all of that. So unless you've got a big team, chances are no one's going to be able to do that.
Okay.
The state might have somebody in a back office somewhere who can text them if they find something juicy. I don't know, but I've very rarely seen social media come up in jury selection just because of the time constraints.
Mhm.
So far as dress, business casual, you want to aim for the middle. You certainly don't want to wear any message t-shirts. You don't want to show up for jury selection in a shirt that says question authority, because the authorities don't like to be questioned. So I would say business casual. You really want to look like a cog in a machine. And that's exactly what they're looking for. They're just looking for parts of the machine so they can just turn the handle on the machine and, print out their convictions without any interruptions.
Mhm.
You don't want to go too far. You don't want to be so much of a supplicant to the state that the defense kicks you off. You just want to stay in the middle.
Mhm.
Now, one thing we haven't touched on that I did
Mhm.
want to bring up
Please do.
is that jury nullification really is a two-way street. Prosecutors go out of their way to demonize defendants. They go out of their way to make the victim look pathetic, and how could this horrible person have done these cruel things to this poor person? They do try to get the jury to convict on an emotional basis, day in and day out. They don't like it when we do it, but let's not be fooled here. Juror vilification is just as common as jury nullification. There are a lot of people who get convicted because the jury says, well, I wasn't there. I don't know what happened, but we
Mhm.
have to give this poor person over here some justice.
Mhm.
And I think we need to start teaching people about jury duty no later than middle school, if they're
Mhm.
going to be able to do it right. It should be part of every 7th grade civics class. We
Mhm.
teach people the role of the president. We teach people the
Mhm.
role of Congress. We teach people the role of the Supreme Court. Most 7th graders will not grow up to sit in any of
Yeah.
those offices, but they will end up on a jury someday.
Yeah. Every
And they
once in
should
a while,
learn
I see
about that
a
as early as they do the others.
yeah. Every once in a while, I see a news story where like a first grade or second grade class has a trial for some maybe like Jack and the Beanstalk or something like that. And occasionally they nullify, and I'm like, all right, well, you know, even kids have an innate sense of when the law is wrong and when justice is different from what the law prescribes. So I definitely agree that encouraging that line of thinking a lot earlier and giving them as part of civics classes those kind of tools would be very helpful. It's a little tough, especially to get into public schools with that kind of information, because the government doesn't want to train people to question the government necessarily. But we have had some success in like speech and debate. Those kind of things come up, and I am working on a section of the FIJA website to give resources to people who are doing like Lincoln Douglas. The topic of jury nullification comes up, and in like when people do a mock Congress sort of thing, to give them tools they can work with and whatnot. So yeah, I definitely agree with that. I'm going to give Tom a couple minutes to fill us in on anything else you think we've missed today that would be helpful to equip people with, and then we'll wrap it up here. I think we've gotten through the crux of my questions.
Well, I think like a lot of lawyers, I'm very interested in history. And I think that if we look at the history of jury trials, there's a lot that we can use and we can benefit by. If you go back to classical Athens, they had jury trials with, I believe, more than 500 jurors that were very well paid. And I'm not sure they even had judges, or they had kind of very kind of a weak type of MC for the jury trial. But and then throughout England and the English history, the Roman history, trials, at least. I think the jury trial is a cornerstone of democracy, and it's really important that the people have a voice in the government and in the system that we have, the judicial system included, judicial system being one of the three branches of government. Yes, we can vote for people, but that's, I guess, what you could call representative democracy. The jury trial is probably arguably the only participatory democracy that we have. And it's super, super important. And the trend has been to go away from jury trials, to push plea bargaining. And even in the federal sentencing guidelines, there's a trial tax built into the federal guidelines. One of our panelists just left to go to a federal case. In federal cases, if you don't plead guilty, you get penalized for going to a jury trial. So I think that that's just one of many examples of, in my mind, it's post-World War II, where we have the government and the culture. There's been an increasing movement away from jury power and jury trials, and arguably more authoritarianism. I think it's up to us people to reverse that and to inform ourselves, fully inform ourselves, and to push back and to assert our rights.
Mm-hmm. And Clay, we have 5 minutes left. Why don't you take about 3 minutes of that to fill us in on any last things you think that we've missed? Go for it, and then I'll take the last 2 minutes, or 1 minute now, I guess, to share a resource with everyone, and take it away, Clay.
Well, I do believe that we need to get this into the popular culture, because if people don't know about their prerogative to nullify before they get into court, the chance of their exercising it in an informed manner is pretty small.
Mm-hmm.
They have to be aware that they have some independence and some discretion to exercise here. The same as the police have discretion, the same as prosecutors have discretion, the same as judges have discretion, jurors have discretion.
Mm-hmm.
And if we want to be serious about rolling back the government, we have to be open to the fact that this also means people we don't like can take advantage of it. It means that there's a lot of talk now about whether the government is going to prosecute Donald Trump. Regardless of what you think of Donald Trump, you're unlikely to get a unanimous jury, whatever the evidence is. So it's symbolic. They're not going to be able to get a unanimous jury. And quite frankly, the same is true of Hillary Clinton for the people who want to see her prosecuted. You're not going to get a unanimous jury. We have to admit that the law is not able to cover every situation, and that's okay. In order to accept the fact that juries have this independent role, we have to admit that if there is no broad consensus of opinion in the population, it shouldn't be an area for the criminal law to get involved in. You shouldn't have 50.1% of the people able to declare the other 49.9% of the people less than people.
Mm-hmm. Well, thank you so much, Clay and Tom. I really appreciate you sharing all your wisdom, and Catherine as well. She had to bug out to go do the work of justice, but I do want to thank her as well. For those of you joining us on Zoom, check your chat. For those of you joining us on Facebook, check the comments. I have just posted a link to FIJA.org/next, where you can sign up for our email, which I hope you will do, because I will be sharing the link to the recording of this afterward. We'll also be getting you information on our upcoming Jury Rights Day celebrations. Jury Rights Day is on September 5th each year, commemorating the famous jury nullification case of William Penn, who was prosecuted for preaching the Quaker religion in Grace Church Street in London, and some of whose jurors refused to convict him. So there's a great story there, and we'll be talking more about how to celebrate that as we get closer to that date. But definitely, I hope you get on our email list. We are definitely going to be having more events like this in the future. As I mentioned today, we're kind of attacking things from the perspective of legal questions and legal answers. But we have also done a webinar with Mike Humer, going at it from a philosophical perspective. I am looking forward to, in the future, being able to put together an event where we talk about things from a spiritual standpoint for those of you for whom that is an important perspective and that sort of thing. So thank you so much for joining us today for Jury Nullification 101. What is it and how do you use it? I hope we have equipped you with enough to get that jury summons, answer your questionnaire, respond for jury duty, do your best to get on the jury, and stick to your guns until you are able to deliver a just verdict. With that, we're going to wrap up for the day. Once again, go to fija.org/next to get on our email list and to browse some of our other resources that we have available on the FIJA website to help you not only become a fully informed juror, but to create other fully informed jurors in your community. Keep in mind that there is one person who will never be on your jury if, in fact, you are the unfortunate soul sitting in the chair of the accused, and that is you. So if you know all of this, but you're the one accused, this doesn't help you. You have to go out and create fully informed jurors in your community now so that they will be available and ready to support you if that day comes when you need a fully informed jury. Thank you so much, Clay and Tom. We really appreciate your time and wisdom. I just can't tell you how grateful I am for you being here.
Thank you.
Thanks.
All right, take care, everyone, and have a great week. We're going to wrap it up, and I will be looking through the chat and questions later to see what others I can answer offline. Take care, everyone, and have a great day.